So let's compare the European GDPR and China's cybersecurity law. These two regulations have major implications for data protection worldwide. So let's break it down, their similarities, the differences, and what makes each unique. Let's start with the scope and application. GDPR, or General Data Protection Regulation, is a broad European law that applies to any organizations, whether it's inside or outside the European Union, that processes personal data of individuals within the European Economic Area. Meanwhile, China's cybersecurity law is more focused on network operators within China, impacting companies that collect, store, or process data of Chinese citizens. These distinctions highlight GDPR's global reach versus China's focus on national data. Now, what exactly is personal data? Under GDPR, the definition is pretty broad. It's basically any information related to an identifiable person, from names to IP addresses. China's cybersecurity law is similar, but emphasizes data that can identify a person alone or when combined with other information. Moving on to the legal basis for data processing. GDPR provides 6 legal grounds to process personal data, including consent, legitimate interest, and contractual obligations. China's laws relies heavily on consent, although national security concerns can override this requirement. One of the biggest differences lie in data localization requirements. GDPR doesn't have strict localization demands, but requires safeguards for cross-border data transfers. In contrast, China's law mandates that certain operators, known as critical information infrastructure, store data within the country unless they pass a security assessment. Now, let's talk about data subject rights. GDPR is well known for empowering individuals with a wide range of rights, like accessing, correcting, and even deleting their data. China's cybersecurity law has some rights too, like the right to know and correct information, but is not as extensive as GDPR. So how do these laws handle breaches? Under GDPR, if there is a risk to individuals, the data breach must be reported to the relevant authority within 72 hours. Data subject must also be informed if there is a high risk. China's cybersecurity law, however, requires companies to report breaches to governing bodies, but it does not specify a precise timeline. Non-compliance can be costly. GDPR imposes hefty fines up to 20 million euros or 4% of global revenue, whichever is higher. China's law also has penalties, but they're usually lower. Serious breaches could still lead to business shutdowns or losing licenses. Cross-border transfers are another critical point. GDPR allows data transfer outside the European Union only if adequate protections are in place, like standard contractual clauses or binding corporate rules. In China, critical information infrastructure operators must conduct a security assessment, while other operators need user consent for cross-border transfers. Now, let's discuss accountability and compliance. GDPR requires organizations to be proactive by conducting data protection impact assessments, appointing data protection officers, and maintaining detailed records. China's cybersecurity law is more focused on cybersecurity risk assessments, regular monitoring, and reporting, with an emphasis on national security. Both laws demand strong security measures, but the focus differs. GDPR requires appropriate technical and organizational measures depending on the risk. China's laws emphasizing regular cybersecurity training, data encryption, and audits to ensure compliance. So to recap, GDPR emphasizes privacy rights for individuals with hefty fines for non-compliance. It's comprehensive, detailed, and has a global impact. China's cybersecurity law, on the other hand, prioritizes national security and data sovereignty with stricter rules for domestic data storage. GDPR is more about protecting individual privacy, whilst China's law focuses more on maintaining state security and control over data.